The next item of business is an urgent question, and I would remind members that the legal proceedings referred to in this question are active and the sub judice rule applies. I admitted the question, having carefully considered its admissibility in relation to Rule 7.5.1 and allowed it on the basis that it is limited to the matters covered in the question and no discussion of the specifics of the case will be permitted. And I call Michael Mara.
Thank you, Presiding Officer. To ask the Scottish Government whether the Lord Advocate will provide details of the reasons for her reportedly sharing confidential details of the charges against Peter Murrell with the First Minister, and whether any further information regarding the case has been made available to ministers or special advisers.
Lord Advocate.
Thank you. I did not brief the First Minister in relation to the prosecution of Mr Murrell or the contents of the indictment. My minute was a factual confirmation of the fact that Mr Murrell had been indicted and the nature of the charge, including the value of the alleged embezzlement. From the point at which an indictment is served, there is no limitation on its terms being made public. The timing of my minute to the First Minister after service of the indictment reflected this. My notification was done to advise Scottish ministers that an indictment had been served, confirm that the appropriate processes had been followed in relation to law officers not being involved in the decision-making in the case, and remind them that it would not be appropriate to make any public comment on the matter. This process protects the administration of justice and does not, I believe, confer any political advantage.
Michael Mara.
In writing to the First Minister, the Lord Advocate provided information that was available to nobody else. That information was then passed on to SNP advisers. The Lord Advocate set out the scale of the charge and the fact that no trial would be held until March 2027. That information conferred clear political advantage to the First Minister. This absolutely stinks. On what planet is it not political interference? Did the First Minister or any of his colleagues or his team ever ask the Lord Advocate or her colleagues for information relating to this case? Why did the Lord Advocate choose to share this confidential information with the First Minister? In fact, why was any detail beyond a simple notice of non-involvement given at all?
Lord Advocate.
The key point that I make is that the minute was sent after an independent prosecutor had taken the decision in the case. It is not an opportunity to influence. It is only information and for the protection of the process. It is about informing of a significant development which is entering the public domain, to ensure the Government is reminded of its legal responsibilities to restrict its comments. It is done as a matter of course, on a case-by-case basis, by the Prosecution Service and on the judgment of the independent prosecutor. In relation to the indictment, this figure that you've mentioned appears on the indictment, and it was a figure that was able to be shared. That sharing of the information does not confer any political advantage or lead to a compromise to the case. This statement was limited to a warning of contempt of court and was accompanied by a notification to the media of a preliminary hearing to support the principles of open justice. So the Crown Office made a statement. The statement was limited to a warning of contempt of court, accompanied by a notification to the media of a preliminary hearing to support the principles of open justice, and then my minute was sent after that the decision was made by the independent prosecutor in the case. I cannot answer the question more fully than that.
Michael Mara.
The Lord Advocate should know that early access to this information does confer political advantage. And this is not standard practice. No. Former First Minister Jack McConnell has said this today, and I quote, "The Lord Advocate is correct to remind ministers that they should not comment in a live case, but I cannot recall ever being briefed ahead of such a case on charges or timetable. and it would always have been particularly unacceptable for such information to be requested for a case where I had any connection to the accused. That is categoric and it is damning. So I ask, how many other times in the Lord Advocate's tenure has she seen fit to share this level of information with a First Minister on live court cases? And does the Lord Advocate not accept that in sending this information to the First Minister, she has compromised them both?
Lord Advocate.
The communication to the First Minister was provided after the indictment was served, at a point where there is no limitation on its terms being made public by the accused. The Crown followed its normal practice of alerting the media to the indictment in the knowledge that the indictment would be shared with the media at a later stage before the case called in court. Public information about court proceedings is provided through the courts in the normal way, and it was appropriate to clarify with the First Minister that I had no involvement in the operational decisions and to reinforce the need for strict observance of contempt of court principles. That protects the integrity of the proceedings and public confidence.
Thank you. I would be grateful if we could hear one another. There are many members wishing to put a question. That will not be possible unless we can hear one another and continue our proceedings. I call Russell Finlay.
Thank you, President Officer. The Lord Advocate was appointed to the SNP government by Nicola Sturgeon. The Lord Advocate then gave John Swinney information about a serious criminal case involving Nicola Sturgeon's husband. She also gave Mr Swinney key details of court dates to the SNP's clear electoral advantage. This smacks of corruption. It undermines public trust in the office of the Lord Advocate, who's supposed to be politically neutral. Any remnants of that neutrality are in ruins. So can the Lord Advocate tell me if she is considering her position?
Lord Advocate.
I am not considering my position. The key point that I've made is this. The minute was sent after a decision had been made in this case by an independent prosecutor. It was not a minute that was sent to seek to influence. It was a minute that was for information and the protection of the process. It's about informing of a significant development which is entering the public domain to ensure the Government is reminded of its legal responsibilities to restrict its comments on a live case. This is a process that is undertaken on a case-by-case basis and on the judgment of the independent prosecutor. I have had no involvement in this case, and any suggestion that I am corrupt or my position is compromised, I roundly reject.
Rona Mackay.
Thank you, Presiding Officer. Can the Lord Advocate reassert that no one has spoken to the Crown on the scheduling of this case? And does she agree with me that any suggestion that the independent Crown would allow any interference in the scheduling of a case, as the opposition is desperately trying to suggest, would never be countenanced?
Lord Advocate.
So, I think I can explain that Mr Murrell appeared on petition on the 20th of March 2025. Criminal procedure limits apply to the case, and those were effective on that date. That meant that the case was subject to extended time limits that were put in place to address the impact of the coronavirus pandemic. This added a period of 6 months to the time limits that would have otherwise applied in criminal trials. Therefore, the time limits that applied to the case were provided in terms of the statutory provisions as it stood on the 20th of March 2025. As Mr Murrell was granted bail when he appeared on petition, the time limits that applied when the indictment was served on the accused were readily available and publicly understood. So that a preliminary hearing or a first diet must be commenced within 17 months of the date on which an accused first appears on petition. And the trial must commence within 18 months of the date on which the accused first appeared on petition. A preliminary hearing is a hearing where the readiness of the prosecution and the defence is assessed ahead of trial, and it's within these time limits that relevant hearings are fixed. These hearings are scheduled by the independent judiciary and the Scottish Courts and Tribunal Service. So Mr Murrell's case is live proceedings, and the independence of the criminal courts is a fundamental part of our justice system. There should not and cannot be political interference in criminal cases. The Scottish Government has had no discussion about the timing of Mr Murrell's case. I understand from media reports that Mr Murrell's legal representatives sought for the date to be changed, and this was agreed by the independent judge sitting in the independent court. It was after the indictment was served on Mr Murrell that I provided the update to the First Minister. The Crown Office have explained that this was to confirm the Lord Advocate was not involved in the case. It was acted for contempt of court and no comment should be made in relation to the case. It simply would not have happened that the Crown Office would have had influence over the decisions in relation to the timing of Mr Murrell's case once it was within the hands of the independent court and the decisions as to the future progress of the case were handled by an independent member of the judiciary. And to say otherwise would be completely wrong, and that simply hasn't happened in this case.
Call Jamie Green.
Thank you, Presiding Officer. I absolutely do not buy any accusation that the Lord Advocate is politically corrupt in this matter. But the Crown was asked why the First Minister was communicated this information about this specific case, and the answer seems to be that this is normal practice. So I think the question remains is how common is it for the Lord Advocate to inform the First Minister about the specifics of an indictment, and I still think that merits an answer from the Lord Advocate. But can I ask a more direct question? If the minute to the First Minister from Ms Bain was offered in her capacity as the Lord Advocate, as the principal legal adviser to the Scottish Government, or both?
Lord Advocate.
So the advice was offered on the basis that I'm the Lord Advocate and I'm the head of the Independent Prosecution Service. In relation to the other point, as I've said before, it is normal practice that sharing of this type of information is done on a case-by-case basis and on the judgment of an independent prosecutor. That is because of the fundamental importance of the protection of live proceedings and to ensure that they're not compromised in any way by commentary that's inappropriate. And it's such an important and fundamental aspect of the rule of law that the importance of the contempt of court provisions and restriction of comments on live cases bears to be repeated in order to curb speculation and inappropriate commentary being applied to any live case. It would not be appropriate for me to say, to give examples of that happening in any particular live case at this stage, without me understanding the impact on the proceedings as they may have at this stage. But I'm happy to share, following on from this evening, information in relation to instances where a similar process has been undertaken in relation to informing the First Minister as to important stages in high-profile and sensitive cases.
Pauline McNeill.
Because there is already concern about the court delaying this case till May the 27th, I have to ask if the Lord Advocate could be more specific about whether or not it's normal practice for a First Minister who is not the complainer in a case to be briefed in this way. And can the Lord Advocate tell Parliament, are there any other aspects of this trial that will be briefed to the First Minister? So I think the Parliament needs to know how many times has this actually happened, because it does seem, if it's the only time, it could be a dangerous precedent to set.
Lord Advocate.
So I understand that it's suggested that there's been a briefing I think it's really important to look at what actually happened here, and it was the submission of a minute to the First Minister that was in 5 paragraphs, and the very limited information that related to Mr Murrell's case only took up a few lines in paragraph 3. We've made the minute available, and it's quite clear that it only refers to the preliminary hearing taking place, the charge, and the tradition of law officers not being involved in the decision-making. And it also says the case remains live, and now that the case has been indicted, further procedure and timetabling for the case will be determined by the court. So that was the content of the minute. There wasn't a briefing as we might understand it. It was very straightforward information was provided. Insofar as the other points that Ms McNeil's raised, there are instances where, in other cases, there has been notification on a case-by-case basis of the fact that there's been a significant development in a particularly high-profile and sensitive case. And that's for the purpose that I've said before, to ensure that there's no inappropriate or unlawful comment on live proceedings. It's critical to the rule of law that is profoundly respected, and that was the whole purpose in sending the minute to the First Minister in this case. We can give other examples of when it's been done, but I'm concerned about ensuring that I protect the integrity of all of the proceedings that these issues might relate to.
Douglas Ross.
The Lord Advocate is offering examples. What we need is numbers. How many times has this happened before? She can surely give us an answer to that. And if she is telling us this has happened more often, have these instances also included the political party that John Swinney is the leader of? Because that's the issue here. As the leader of the SNP, he got information that was not available to anyone else. So how many cases, and of the other cases, did they also include the Scottish National Party? Because if not, then it's a totally different situation. And secondly, the Lord Advocate is trying to put this across as something that is perfectly normal. So why, on the same day that she sent a minute to the First Minister with information about this case, was the Crown Office telling reporters that the only information that could be made publicly available was the date of the preliminary hearing?
Lord Advocate.
So, in relation to numbers and examples, just referring back to the question that I was asked, and I don't see that formulated in the urgent question, but I can give.
Let's hear one another, colleagues.
I can, after today, after this evening, provide more details of how many.
Mr Ross, let us hear the Lord Advocate.
So I can, after today, give other examples of circumstances where this has happened previously. And I would be able to give numbers and examples as I can, but I really need to say this, that I have to protect ongoing live cases in respect of which there has been a sharing of a significant development that is entering the public domain in a sensitive case. And the point is this: in this case, the point had reached that it was a case that was highly sensitive, it was a significant development, and I was seeking to ensure, to remind the government to respect the rule of law and to restrict its commentary on such an important matter.
Point of order, Douglas Ross.
Our standing orders, Presiding Officer, make it very clear that if a minister answering questions has information available, they must provide that in response to the answer. The Lord Advocate has said very clearly she has an answer to my question, but she will only provide it after this session. That is not acceptable in a Parliament that the Lord Advocate has been called to provide answers to, and it is in breach of our standing orders.
Thank you, Mr Ross. The contribution that members make in this chamber is not a matter for the Chair. It is a matter for the Minister, is a matter for the Scottish Government as to their response. I call Ross Greer.
Thank you, Presiding Officer. Can I echo the colleagues who have rejected the deeply irresponsible allegations of corruption against the Lord Advocate? And I accept that there is a precedent for informing the First Minister of significant cases. I welcome that she's going to supply Parliament with examples, but I want to repeat the specifics of Jamie Green's question, because while also recognising that she can't comment on the specifics of a live case, what I would be keen to understand is not why the First Minister was informed of the developments in this case. I understand there's precedent for that, but why the detail was included, the figure, the £460,000 figure. If the Lord Advocate could explain why that detail was included in the update to the First Minister, I would certainly appreciate further clarification on that point.
Lord Advocate, and I would remind members to avoid mentioning specifics of this case.
So the figure appears on the indictment, and it was a figure, therefore, that I was able to share. As I've said before, the fact is, from the point at which the indictment was served, there's no limitation on its terms being made public. And the timing of my minute to the First Minister after service of the indictment reflected this. I think it's also important to say that I am answering to Parliament today, but it really isn't appropriate to comment on the substance of a live case beyond matters of process. And I would simply reiterate that it's critically important to protect this live case to ensure that justice is served at the end of the day. And I repeat the position, which is this. The key point is that the minute was sent after an independent prosecutor had taken the decision to indict the case. It was not an opportunity to influence this case at all. And it was about informing of a significant development which was entering, at that stage, the public domain. And I was seeking to protect the process, because that is what, as a Lord Advocate, I'm required to do, to uphold the rule of law and protect the process.
Rachel Hamilton.
Thank you, Presiding Officer. The Lord Advocate says that sharing details with the First Minister is normal, but does she, however, accept that now that the correspondence has been shared with the wider public just weeks before an election, this risks undermining the confidence in the impartiality of the prosecution service?
I didn't choose
Lord
to.
Advocate.
I don't accept that, and I think it's worthwhile looking back at how this has all developed. The minute was sent.
Let's be courteous. Let us hear one another in a courteous, respectful manner.
Yeah. So the minute was sent because of the significant development of the details of the indictment entering the public domain. And the minute was therefore sent by me to ensure that we had a transparent process from which we could see that I communicated the significant development to the First Minister, and I ensured that it was made clear that independent prosecutors had been involved in the case, and also to make it clear that there was legal rules that restricted commentary. That's the whole purpose in sending it. The fact that these questions are being asked here today, following on the release of the minute that resulted from a freedom of information request, is why the timing has come about, in the sense that this is, in terms of the forthcoming election, it's not my making. It's the process that's been involved in this freedom of information request and the
Let's not shout.
Thank you. The freedom of information request and the minute becoming available. That's how we're here now in terms of timing. So that the timing is not one that I have chosen. And if that's the criticism, then it's not down to me.
Daniel Johnson.
Thank you, Presiding Officer. What is in no doubt is the importance of the separation of legal proceedings from both government and from politics. And indeed, it's certainly the case that the importance of her position being independent is clear. But the Lord Advocate needs to explain that if she was intimating these details on the basis that they were, in her words, significant, can she explain how she defines that significance? Because that's absolutely what is critical here and why it was relevant for the First Minister to know. And secondly, if this is routine, if this is something that happens as a matter of course, she seems to be indicating in her answers so far that she's unable to provide the information about the number of cases. Is that the case, that she's unable to as of now? And most critically, can she at least say when the last occasion was that she intimated the details of an indictment on a similar basis?
Lord Advocate.
So I've explained today that I can provide those details and I would provide them in writing after this evening. I don't have that information today, and because of the fundamental importance of protecting ongoing live proceedings, it's critical for the consideration to be applied appropriately to the information and thereafter for the information to be shared. And I haven't said I'm unable to provide it or refusing to provide it. I'm just simply saying at this stage, standing here, I can't give a full answer, but I will provide it in writing afterwards. The other issue that you've asked is about how do I characterise a significant development in a case? And I characterise a significant development as one that relates to a significant step in process. And so here, in this case, a significant step in process had taken place because an independent prosecutor had decided that the indictment should be served. And therefore, in order to protect the process and the integrity of the proceedings, the information of this significant development was notified to the First Minister in the terms that set out in the minutes, and it was reminding the government to restrict commentary on what was a highly sensitive case. And we know that because of why we're here today. It's a highly sensitive case that requires to be prosecuted independently and fairly, and I'm seeking to ensure that that is exactly what's delivered in such an important case.
Liam Kerr.
Presiding Officer, did the Lord Advocate share this information into what is, at the end of the day, a politically staffed office proactively and upon her own volition, or was the update specifically requested by the First Minister and/or anyone in his office?
Lord Advocate.
So the update was shared after my advisers told me of the significant step in process, and the minute was sent to reflect that. And I think that's clear from the terms of the minute that is public, and it wasn't requested.
Fergus Ewing.
Thank you, Presiding Officer. The Lord Advocate has emphasised repeatedly this afternoon that she had not only recused herself from any involvement in the decision-making process in this particular case, but also that she only issued this minute in her name because that was the fact and the indictment was settled. But doesn't she agree with me, Presiding Officer, that the terms of the indictment can be altered after service? That is trite law. Charges can be added with permission of the court. Charges can be removed. So I'm not making any allegations against the Lord Advocate, with whom in my dealings I've always found her to be someone of absolute integrity, and I want to put that in the record. But it's surely a legitimate question to ask, having recused herself, would it not at least have been prudent and politic if an intimation was to have been made to the First Minister that that intimation should have been made by the named senior prosecutor in charge of leading the case? And had that been done, she probably wouldn't be here today facing a number of pretty obvious and serious questions to which the public are entitled to have direct answers.
Lord Advocate.
Mr Ewing is quite correct about the process that follows on the service of an indictment. And it's correct to say that charges can be amended, and it's correct to say they can be added to in terms of narrative and the like. So Mr Ewing is a well-qualified lawyer, and he understands all of the issues surrounding an indictment and its contents and the legal rules that apply to how that's processed during the course of any prosecution. The contact with the First Minister was made by the Lord Advocate because it was appropriate by the Lord Advocate to clarify that I had no involvement in operational decisions and to reinforce the need for strict observance of the contempt of court principles. That protects the integrity of proceedings and public confidence.
Graham Simpson.
Thank you very much. Can the Lord Advocate tell us, has the First Minister, anyone in government or anyone connected to government ever asked to be kept informed about this case?
Lord Advocate.
Not that I know of.
Thank you. I call Martin Whitfield.
I'm very grateful, Presiding Officer. Can I ask when it became standard practice to notify, under the Contempt of Court Act, the First Minister's office?
Lord Advocate.
So I know it's a long-standing process, and I can get the details of that to the questioner without any difficulty, and there will be examples that can be given dating back some significant time, and I'm quite happy to share that, and we can do that after today. I simply don't have the material here.
And Stephen Kerr.
The reason that the word significant keeps being used in connection with this particular case is because it involves the Scottish National Party. And when alleged criminality touches the governing party, even the perception of preferential access, such as this, because that's what it is, risks undermining public confidence in the independence of Scotland's prosecution service. So what steps will she now take to ensure that public confidence is not further undermined in this way?
Lord Advocate.
This was not preferential access. I did not brief the First Minister in relation to the prosecution of Mr Murrell or the contents of the indictment. The minute was simply a factual confirmation of the fact Mr Murrell had been indicted, the nature of the charge and the value of the alleged embezzlement. From the point in which the indictment is served, there is no limit on its terms being made public. The whole purpose in the intimation to the First Minister was because of the significant development. I accept it's a significant case, but there was a significant development because of the fact of information entering the public domain at that point. And so I would just be repeating myself to say the purpose in intimation was quite the opposite of what is being suggested. It was to ensure that the government was reminded to restrict its commentary for good reason. That was to protect the integrity of a significant and serious prosecution that has been taken up by independent prosecutors in the Crown Office.
Thank you. That concludes the urgent question. The next item of business is consideration of Business Motion 20826 in the name of Graham Day on behalf of the Parliamentary Bureau setting out a business programme, and I call on the Minister to move the motion.
Move, Presiding Officer.
Thank you. And I call on Douglas Ross to speak to and move Amendment 20826.1.
I'm glad the Lord Advocate and the Solicitor General are remaining in the chamber for this debate, because it is a request about the Lord Advocate's time, and I hope she would accede to this, and I will give way at any point if she wishes to intervene. But there are many questions that have not been answered in the last 30 or so minutes. Many questions that were put to the Lord Advocate that were not addressed in her responses. But more worryingly than that, Presiding Officer, I believe in breach of our standing orders, and I respect your ruling. We know that the Lord Advocate is aware. We know that the Lord Advocate is aware of answers she could provide to parliamentarians, but has decided not to give them to Parliament today. She is going to write to Parliament later on. Therefore, I think it would be very helpful if we can have a full statement from the Lord Advocate tomorrow. So the amendment to the business motion I am introducing today is to seek a full statement from the Lord Advocate tomorrow with questions put to her. And there are questions that still need to be put. For example, I asked the Lord Advocate very specifically why on the same day that she was sending a memo to the First Minister was the Crown Office also telling reporters that they could not receive the same information that the First Minister did. And I'll give way to the Lord Advocate if she wishes to answer that just now. Well, this is why we need a statement tomorrow. This is why we need a statement tomorrow. There are other...
Let's hear one another.
I think it is a serious question. It is a serious question. How can the Lord Advocate come to Parliament and say that the information she provided to the First Minister in a memo was not then allowed to be shared with reporters who were asking her office for that information? That is a clear issue that we need an answer on. And because the Lord Advocate refused to provide that in her answers earlier, I think that's a very good reason for having a statement. We also didn't even get to the point of the Lord Advocate potentially being concerned about this SNP government. I wrote it down. They had to be reminded of the legal issues surrounding this case. Those are the Lord Advocate's words. Those are the Lord Advocate's words. She felt, I will give way in a moment, she felt so concerned about this issue that she had to draft a memo to the First Minister. She was concerned that John Swinney would not understand the issue.
Let's hear one another.
I said I'd give way in a minute. The Lord Advocate was so concerned that Scotland's First Minister would speak inappropriately about this case, he had to be briefed about it. We also don't know from the Lord Advocate if she has any concerns that on receiving that email, the First Minister, and I know his Chief of Staff came into the chamber just a few moments ago, that was then, on receipt from the Lord Advocate, forwarded on to SNP Special Advisers 31 minutes later. So did the Lord Advocate, in sharing that information with the First Minister of Scotland, believe that was going to be shared with political special advisers? These are all points that I think this Parliament deserves to hear about. This is why there were topical questions put in today, but even at the end of that process, we have so many unanswered questions from the Lord Advocate. So I repeat in conclusion that I think a statement is needed tomorrow, a full statement from the Lord Advocate to provide answers. And if the Lord Advocate and SNP members are happy, nothing has gone wrong here, everything is perfectly acceptable and above board, then come to Parliament to tell us that. Come to Parliament, give a statement and allow questions to be put. Because even after today's urgent question, there are many queries that remain, many queries that were put to the Lord Advocate that were not answered, many pieces of information that have now been promised to MSPs to come later on today, and therefore we should be able to challenge that tomorrow. And ultimately, if there is nothing to see here, nothing to hide, then why not come back tomorrow, deliver a statement, be questioned, which is why I move the amendment in my name.
Thank you. And I call on the Minister to respond on behalf of the Parliamentary Bureau.
Officer, Douglas Ross's amendment to the business motion is to seek a statement from the Lord Advocate tomorrow on communications in relation to Mr Murrell's case. However, as members have just heard for the last half hour, the Lord Advocate has come to Parliament today to answer the urgent question lodged by Michael Mara on this very subject. The urgent question process has allowed this to happen, and 14 members with an interest have had an opportunity to ask the Lord Advocate questions in relation to the subject. I mean, if Mr Ross would show a bit of courtesy and listen, that would be useful. No, I think we've had more than enough performative nonsense from Mr Ross. The Lord Advocate has answered these questions and, as such, and are also committed to provide further information in writing. MSPs have therefore had an opportunity to provide scrutiny of the Lord Advocate in this area. Given that,
Mr Ross, please resist the temptation to contribute from your seat.
Thank you, Presiding Officer. It's also the case, of course, that members will have the opportunity to explore this further tomorrow, MPs, if they so wish. Given all of that, I do not consider the amendment requiring a statement tomorrow should be supported, and I ask Parliament to reject it.
Thank you. The first question is that Amendment 20826.1 in the name of Douglas Ross, which seeks to amend Motion 20826 in the name of Graham Day on behalf of the Parliamentary Bureau setting out a business programme, be agreed. Are we all agreed? The Parliament is not agreed. Therefore, we will move to a vote, and there will be a short suspension to allow members to access the digital voting system.